Hey everybody, John Michael Bailey, John Michael Bailey Injury Lawyers. Today I am very pleased to welcome as our special guest, and one that will be returning, Mr. Mark Lambert. Mark has been with the firm for a number of years, probably more than he wants to admit. He's our chief legal officer, and one of the many specialties that he has is in the area of workers' compensation. Now, let me brag on Mark for a little bit and say that we get a lot of referrals from a lot of other law firms on complicated workers' comp issues because Mark is recognized as having superior knowledge and expertise in those areas. He's very, very well versed in the area. He has a book coming out that we'll be telling you guys about in later episodes. And today, Mark and I are diving into the workers' comp system. Now, primarily, we focus on two states, Tennessee and Mississippi, but a lot of this is applicable all the way through. This is a system that everybody thinks they understand, usually up until the moment that they need it, and then they realize that what they thought was true isn't. So, without further ado, let me introduce Mark and let Mark say whatever he's got to say, and then we will dive right in.
John Michael Bailey, I'm here to tell everyone what they want to know or don't want to know about workers' compensation. I'll answer all your questions and I'll give you all the knowledge that I've got.
Well, you always do. If there's one thing I can count on Mark, he tells me exactly what he thinks, whether or not I like it. Okay, so I'm going to ask Mark some questions that sound obvious, and he's going to crush everyone's hope with the real answers. But all of that will be mixed in with the best advice that we can give you. Let's start with one that we hear all the time. Can I sue my employer? Okay. The answer is yes and no. This is what I meant. It's a very complicated area. So I'm going to pose a question to Mark and let Mark walk us through his thoughts and his advice and what he thinks the law would do and apply to the situation that I described. Here's one that we hear frequently because Memphis is a distribution center. So Mark, I'm working on a conveyor belt. It's basically held together with duct tape and corporate optimism. It breaks down all the time. It is notoriously unsafe, rickety. People on the line complain to management all the time about, hey, if you don't fix this, somebody's going to get hurt. Well, I'm working on that conveyor system. I turn and I go to put a box or a piece of equipment on that conveyor system, a belt breaks or a spring unsprings or whatever, and I lose the tips of 3 of my fingers. Can I sue my employer for that kind of an injury?
Unfortunately, John, the answer is a big fat no.
Okay.
Tennessee and most states have a system that's called the exclusive remedy for workers' compensation. And what that fancy legal word means is that the employer is protected by the workers' compensation laws. The laws were put in place to make sure that employees were given something as part of their bargain that they had with the workers' comp system, that they're able to get some type of recompense for their injuries that they've gotten. But what that means is that you can't sue your employer directly in negligence. You're stuck with whatever benefits you're entitled to through the workers' compensation system. Now, that
Okay.
sounds very simple, but anything is simple if you don't ask enough questions about it. And the workers' compensation system is no different.
Okay. Well, what are the questions that I should have asked that I didn't?
The first question would be, was it your employer that really held that together with duct tape? Or did they have a contractor that came in and duct taped up that conveyor belt?
Does that make a difference?
It makes a big difference because
Well, tell us about it.
even though the employer is protected, that contractor that came in may not be. We may be able to find a different avenue for you to pursue, a different way for you to go after someone to get some money besides what the workers' compensation system is sticking you with.
Okay. You and I kind of already know where you're headed with this, but can we just put a pin in that for the moment? I do want to come back to that. And will you explain to people what you say stuck with what the workers' comp system sticks you with? What does that mean?
Sure. The workers' compensation system in every state and federally is set up as a balancing act so that you don't have to prove negligence on the part of your employer. You don't have to prove that they did anything wrong, but you don't get all the types of benefits that might be available to you in a common law action like a car wreck or a slip and fall in a store, you're limited to really just whatever the legislature has decided is fair.
So does that mean you can't sue them for negligence?
Correct.
Does that mean you can't sue them for pain and suffering?
That is correct. There is no pain and suffering in the workers' compensation system. All those elements of damages that we would have in a common law system, where you might slip and fall in a store, you might have a car wreck, such as pain and suffering, loss of consortium, lost future wages, all those things are not available in the workers' compensation system. It's limited to just a very short list of what the legislature has decided makes the system fair and will make you whole.
And the legislature, who is constantly lobbied by corporate interests, tends to take care of the employers and not the workers. Is that a fair statement?
I think it's safe to say that the legislature in this state and all of our surrounding states are very business oriented and anti-labor. I think that is a fair statement.
Okay. So that's why it makes a big difference on whether it's actually your employer or somebody else. Is that right?
That's exactly why.
So if it was somebody else who poorly maintained that conveyor belt, then in that event, you could sue that person. Is that right?
Correct.
Or entity, corporation, and still have all the remedies that you would have, say, in an auto accident or a slip and fall.
It's better than that. You can have two different actions.
Two?
You can have your workers' compensation action that provides you with your medical care and a little bit of money to get you through, to get you by while you're off work. And at the same time, maintain a lawsuit against the person who really caused the damages, that contractor. You get the best of both worlds, but only if you know what to look for and what to ask for.
And I bet you're going to tell us that you know what to look for and you know what to ask for.
I just might.
Okay, that's good to know. Now listen, you brought up something that I want us to go back over and make sure that everybody understands. You said in the workers' comp system, you get a little bit to help you get by. Now, would that be temporary total wages, perhaps?
If you're taken off work by a doctor, and we're going to talk about your workers' comp doctors in a minute, but if you're taken off work by a doctor and the employer can't accommodate some of your restrictions you might have, then the workers' comp system lets you have temporary benefits to sort of get by. Is it your full paycheck? No. It's 2/3 of your paycheck in most states, which for most people still puts them at a hardship, but it's at least something that's you're going to be able to get throughout the pendency of your treatment.
And also, I think we should point out that the doctor that you see, and we're going to talk about that, it's not your doctor, it's really their doctor, but you don't have to pay for that. Now, that may not be any benefit at all, but at least you don't have to worry about the medical bills. So in a workers' comp system, they take care of the doctor. And again, you'll explain whether or not that's a benefit. And they give you a little bit to get by on.
The medical treatment's actually some good news, because whether it's a $10 bottle of aspirin or $10,000 surgery, the medical treatment is unlimited. So
okay.
No matter what it costs in
well,
the workers' comp system, you're entitled to that medical care for free.
Well, that is a little bit of good news. Now, the difference would be if it is a two-party thing where you're going against somebody who is not the employer, during the pendency of that action, the person who injured you, now this is just like any other injury case, they don't pay for the medical bills. You have to figure that out on your own, okay? And they don't pay you any kind of lost wages during the pendency of the action. So that's the balancing that you're telling us about. Is that right?
That really is the occasion when you get the best of both worlds. Here in Memphis, let's just be honest, we have some bad drivers. And many times people are injured whenever they're on the job. So let's say you're on the job making a delivery of some type, or it's part of your work, and you're in a car accident and it's not your fault. The good news is we can open up both types of claims. We can file an action against the person that caused the accident, and we can open up a workers' compensation claim. That's really the best of both worlds. That doesn't happen all the time. It doesn't even happen most of the time, but it's definitely something that we look at to try to make sure that it's not missed.
And I will say that I'm very proud to say that our intake team, the people that first answer the phone and start speaking to you about the cases, we train them very, very much. Mark has trained them very, very much. We know how to look for that. And that's why we always ask in the very first phone call that we have with you, were you on the job when this happened? And you'd be amazed how many people don't think that that is important, but it is. Again, it leads to exactly what he was talking about, which is the best of both worlds. Now that we've kind of gotten started, why don't you give a quick overview of how the body system is valued? And then in our very next segment, which is forthcoming, we'll get into that a little bit more.
Everything in workers' compensation is based on a formula. And the legislature has decided that the entire human body is worth 450 weeks of benefits. 1 week of benefit is equal to 2/3 of your average weekly wage. So we're going to talk about this in a way that sounds simple. Of course, as we said a minute ago, everything is simple if you don't ask enough questions. That average weekly wage is based on the last year that you worked for your employer. Now that's simple if you've gotten paid the exact same amount and you've been there for more than a year. When it gets complicated is when you've just started that job. You've just been there for 2 or 3 days, or you started that job and you were promised a raise, or you just got a raise, or there's some other extra kind of benefit you get like mileage or some type of bonuses. It gets very, very complicated trying to figure out even to the very root of the workers' comp system what that average weekly wage is. When we finally agreed on that, and it's rarely something we agree on quickly, when we finally agreed on that and fought for that to get as much as we can, we know that's what you're going to get paid while you haven't been taken off work by the doctor. A time will come when that doctor says that you've reached your maximum level of improvement, and that doctor, he or she has an opinion as to what your percentage of disability is. That percentage of disability is just a number of weeks. 10% is 45 weeks. 1% is 4.5 weeks. It's a percentage of 450 weeks. Again, frankly, insurance companies are going to tell you how simple the system is. It's just a number. It's just a formula that we plug things into. But if you don't talk to the doctor and you don't look at the books the doctors have used to come up with those numbers, you don't realize how easily flawed the system is and how you can help the doctor understand exactly what you're going through and get some changes to those numbers to increase the amount of benefits you're entitled to. That formula also doesn't take into account the fact that maybe at your age, it's hard to get a new job. Maybe at the education level that you have, it's hard to get a new job. Maybe this employer is just out to get you and they're just not going to take you back to work. All those things come into play whenever we start to resolve the workers' compensation case at the end of it. All of those things are called extraordinary benefits. All those things are important to get the vocational loss that you've had, not just the anatomical loss that you've had from this injury.
Well, I see we still have a lot to talk about. Okay, we're going to wrap this one up and we will be right back. So stay tuned, subscribe, hit that notification button so that you will not miss our next one coming up. We're going to have Skinny the Skeleton join us, and Mark will go through all the things that we still need to talk to you about what's an upper extremity, what's a lower extremity, what are the things that go into figuring out what your actual impairment is and what that means to you and your life going forward. So everybody, if you can hear our voices, we both wish you peace and joy. And as always, if you need us, you know where to find us. 888-WE-FIGHT. We're here 24/7, 365. We never close. If you're hurting, we are working. And as always, we would love to talk to you. Talk soon. 888-WE-FIGHT.